I'm curious. You're listening to his testimony. It apparently was very relevant to the defense in the case, and as is indicated in this brief, they didn't call him because on two bases they're arguing there was a problem here. One, the judge allowed those notes to go out that you opined about before, and secondarily, ineffective assistance of counsel. They should have called the doctor anyway. Can you talk to our audience about your opinion as to the value of this kind of testimony in front of a jury when it's a case of circumstantial evidence, is whether it was his intent to murder or whether this was just a tragic and unfortunately often occurring experience that people forget. I've known my own friends that have done this. Leave the kid in the car. Thank God nobody died. What are your thoughts about all that?
So I think it's an extraordinary piece of evidence anytime that you can bring an expert into a courtroom to help explain to a jury facts that they may not otherwise hear from direct evidence. And, that is the primary difference between an expert witness and a lay witness. A lay witness, while we have lots of exceptions, generally they have some level of personal knowledge of what's been alleged, and they're there to support one person's theory or the other. While on the other hand, an expert comes to court with a individualized set of skills based on their life experience, their education, and so on. And they are allowed to speak about things that they do not have personal knowledge of and apply those to the facts that have been in front of the jury. For example, we heard Dr. Diamond testify about individuals who leave their guns, in a stall. And we saw some objections from the prosecuting attorney. But, ultimately, that expert was trying to, or at least in the context of this hearing, create some context for support of his theories that he had been discussing. And that is that we get into routines and so on and so on. I don't want to pretend to be an expert in his field, but we get into routines and habits, and it doesn't take much to pull someone out of that, out of their routine where they would forget something they normally would not do so. He used the example of the car seat, the metaphor. These are things that a lay witness would never be able to testify to. But in this circumstance, he's able to bring his life experience, his education, his research, and what the basis is that he believes that we saw the uptick in children being left in their car and ultimately being injured. So I, try not to draw judgment on this case. I agree with you, Bob, and I think Imran, in that this is a very, very tough case to prove any sort of intentional act on. But to your specific question, as it pertains to expert witnesses, I don't know, not knowing what quote unquote notes may have been out there, to not take the opportunity to explain to the jury in a scientific way from a man that's been doing this for 10 years. I think that that's an arguable huge mistake on the part of trial attorneys.
Yeah, excellent points there. Very important witness for sure. The expert being allowed to give the opinion based upon information. And we have a lot more about that expert, what the state also was attempting to do by precluding them from getting out things like are very common. I can't count how many times I'm driving to work and all of a sudden I get off the exit from my house, or I'm going to my house and I get off the exit to go to work. It's a common human experience. We're going to be back on